Hello, I am here to speak about a project that the Competition Division was asked to prepare for Australia, comparing its pecuniary penalties for competition infringement with those of other members of the OECD. This project, which led to this report, builds on previous work pursued by the OECD regarding the sanction of competition infringements. The report begins with a thorough analysis of the Australian system, which revealed a few interesting features of this regime, including, more notably, that penalties are set by generalist federal judges, and that those judges follow an unstructured method called the instinctive synthesis, which seeks to take all relevant factors into account. We then had to select the relevant comparative jurisdictions. All regimes had to be established jurisdictions like Australia, but they also had to reflect the characteristics of the Australian system, such as the size of its economy, its legal tradition, who sets the penalties, whether there are additional sanctions, and the prevalence of public and private enforcement. As this slide shows, we achieved this goal by selecting the EU, Germany, Japan, Korea, the UK, and the US. While no jurisdiction perfectly matches Australia, when taken together, these jurisdictions share all the main characteristics of the Australian regime. Our analysis showed that there seems to be an international method for setting of fines regardless of the individual characteristics of the system, as shown here. All comparative jurisdictions follow a structured approach to the setting of penalty amounts, which is publicly available and which has the goal of ensuring deterrence. This structured approach follows three main steps. First, a base penalty is set. This base penalty tries to reflect both the economic impact of the competition infringement and its seriousness. Economic impact is reflected in the use of proxies to identify an initial fine amount, such as the turnover or value of commerce of the activities of the infringing parties in the market affected by the anti-competitive conduct. Seriousness is then taken into account by the application of higher or lower percentage rates to this initial amount. The more serious the conduct, the higher the percentage of the initial amount that will be taken into account in our calculations. All systems then apply a large number of mitigating and aggravating factors to this initial amount. And lastly, all systems allow discretions to adjust the amount of the fine, either upwards to ensure deterrence or downwards, to ensure that the penalty is proportionate and not oppressive. The last stage of our report compares Australia to the international method. We first concluded that all regimes have as the main goals to deter anti-competitive conduct. We also concluded that the factors taken into account to aggravate and mitigate the amount of a sanction are similar in Australia and elsewhere. However, a number of differences emerge from our analysis. First, Australia does not follow a structured approach to penalty setting. Second, Australia does not have any public guidance as to how penalties are to be calculated, other than the case law on the instinctive synthesis. Lastly, Australia does not take into account the economic impact of the infringing conduct when setting penalties. This has two dimensions. Neither the turnover or volume of sales in the market on the one hand, nor the duration of the infringement on the other, are explicitly taken into account when setting penalty amounts. We then tried to determine whether this had any impact on the amount of penalties effectively set by Australia. We did this by applying the structured approach to a number of cartel cases decided in Australia. From this comparison, emerged that the average penalty in Australia is more than 10 times lower than the average base penalty in comparative jurisdictions. You can see more detail in this slide. While we were unable to conclude that there is a causal relationship between these two phenomena, namely not following the international method on the one hand and on the second hand imposing much lower pecuniary penalties, it is plausible that these phenomena are related. The report then ends with some recommendations to ensure that pecuniary penalties are sufficiently deterrent. These include somehow linking the amount of the penalty to the economic impact of the sanctioned company's conduct and to the seriousness and duration of the infringement, and reflecting this method in public guidance, and secondly, studying whether to develop and adopt a structured method for the calculation of the amount of pecuniary penalties in line with the international method. You can find that in greater detail in this report, which you can find in the OECD website. Thank you very much.